The courtroom went quiet the moment Aldous Pemberton walked in. Not the kind of quiet that follows a judge's gavel, the kind that spreads person to person, row by row, the way cold air moves through a room when someone opens a window in winter. People stopped shuffling papers. A paralegal near the back looked up from her phone. One of the junior associates at the plaintiff's table leaned over and whispered something to the man beside him. And that man, 31 years old, custom suit, hair that cost more to maintain than most people's car payments, turned around to see what everyone was looking at. He saw a janitor, 71 years old, gray work shirt with a name patch above the left breast pocket. Khaki pants with a crease that had been ironed in so many times the fabric had started to thin. Shoes worn flat at the heel. He carried a small canvas bag over one shoulder, the kind you buy at a drugstore for $4, and he walked with the careful step of a man whose left knee had been repaired twice and never fully forgave him for it. Nobody in that courtroom looked at Aldous Pemberton and saw what was coming. That was the thing about Aldous. Nobody ever did. The town of Harwick, Ohio sits 40 miles east of Columbus in a stretch of country that used to mean something. Steel plants, a rail yard, 3 union halls that once negotiated wages for 12,000 workers. The plants closed. The rail yard scaled down to a skeleton crew. The union halls became a storage facility, a church, and a parking lot in that order. What remained was a town that had learned to live on less and call it dignity. Aldous Featherstone Pemberton had lived in Harwick his entire life. 71 years, same house his parents had bought in 1961. A 2-bedroom on Orchard Street with a porch that sloped slightly to the left, and a furnace that made a sound like a cat complaining every time the temperature dropped below 40. He had repaired that furnace 11 times. He knew the sound it made before it was about to fail. He knew the sound the stairs made when rain was coming. He knew every crack in every wall of that house, the way you know the face of someone you have loved for a very long time. He was a janitor at Harwick Regional Medical Center, had been for 9 years since the auto parts warehouse, where he'd worked for 22 years before that shut down and moved its operations to a facility in Tennessee. He took the hospital job without complaint. He mopped floors, he sanitized rooms. He wheeled patients from registration to imaging. He replaced light bulbs in hallways that nobody noticed until they burned out. He learned the names of the nurses on every floor and which ones took their coffee with sugar and which ones preferred it black. And on nights when the ER was overwhelmed and nobody had time to breathe, he quietly refilled the break room coffee and left without saying anything about it. He was not invisible to everyone, but to most people, he was exactly what they saw. An old man in a gray shirt, doing the work the building required, moving through the corridors of other people's important days. His granddaughter, Camille, was 22. She had her mother's eyes and her grandfather's stubbornness, which meant she was both beautiful and entirely impossible to argue with. She was finishing her last semester of pre-law at Ohio State when it happened. She had taken a part-time job at Langford and Associates, one of Columbus's larger civil litigation firms. Not a prestigious job. She answered phones, filed documents, made coffee that tasted like disappointment. But she was good at it, and she was learning, and she was paying attention to everything. The firm's managing partner was a man named Vincent Schaefer, 44 years old, third-generation attorney, whose grandfather had started the firm in 1968 and whose father had built it into something formidable. Vincent had inherited both the firm and his father's complete confidence that he deserved it. He wore cufflinks to depositions. He spoke in the slow, measured cadence of a man who had never been interrupted and didn't expect to start being interrupted now. He had a photograph of himself on the office wall, shaking hands with a senator, and another one with a federal judge, and a third that was just him standing next to a very expensive boat. Vincent Schaefer did not learn people's names unless he had a reason to. He did not have a reason to learn Camille's name until she made a mistake with a filing deadline on a minor insurance case. A clerical error, the kind that happens in large offices with poor communication. And Vincent called her into his office in front of 4 other associates and told her that this was exactly why certain people didn't belong in law. He didn't say which certain people. He didn't have to. Camille kept her face still. She said, "Yes, sir, I understand, and I'll make sure it doesn't happen again." She left the office. She drove home to the apartment she shared with 2 other students, sat on her bed, and called her grandfather. She didn't cry when she told him. She was the type who didn't. But her voice went flat in the way that voices go flat when a person is holding something heavy and trying not to show how much it weighs. Aldous listened. He didn't say much. He never said much on the phone. When she finished, he sat quietly for a moment. Then he said, "I'll come see you Saturday." "Grandpa, you don't have to. I'll bring the sweet potato pie. I made 2. Your mother can't have all of it." Camille almost laughed. Almost. He drove to Columbus on Saturday. They ate pie at her kitchen table and talked about nothing important for an hour. When he left, he hugged her at the door, the way he had hugged her since she was small. Both arms. Like he was trying to memorize the shape of the moment. And then he drove back to Harwick. He didn't say anything about Vincent Schaefer on Saturday, but in the weeks that followed, Aldous Pemberton began to pay attention. And Aldous Featherstone Pemberton, when he began paying attention, was an entirely different kind of man than the one people saw pushing a mop down a hospital corridor. What nobody in Harwick knew, what almost nobody anywhere knew anymore, was that before the warehouse, before the night shifts and the worn heels and the $4 canvas bag, Aldous had been something else entirely. He had spent 18 years as a constitutional law professor at Case Western Reserve University School of Law. Not an adjunct, not a visiting lecturer. A tenured full professor, specializing in civil rights litigation and equal protection doctrine. He had published 4 books. He had argued twice before the Sixth Circuit Court of Appeals. He had co-written an amicus brief, cited in a Supreme Court opinion in 1997. His students had gone on to become judges, public defenders, senators' counsel. He left the academy in 2003 when his wife, Agnes, was diagnosed with early-onset dementia. He took care of her for 7 years. When she died, he was 62 years old with a gap in his employment history, and a grief so vast he had to learn to live inside it, the way you learn to live inside a house after a flood, carefully, room by room, not opening certain doors. He had no interest in going back. The classroom felt like a place that belonged to someone he no longer was. He took the warehouse job because it was available. He took the hospital job because the warehouse closed. He kept his books on 2 shelves in his bedroom and his bar card current, though he had not used it in over a decade. He had told almost no one, not because he was ashamed, because it no longer felt relevant. The man who had stood in front of lecture halls and broken down landmark civil rights cases was the same man who now refilled the break room coffee in silence. They were both true. Neither one was more him than the other. But then Camille called, and Aldous began paying attention. What he found over the following 6 weeks was not what he expected to find. He called Camille's supervisor at the firm, not to complain, just to ask questions, the way a curious old man might. He talked to 2 former employees of Langford & Associates who had left in the past 18 months. He spoke with a woman named Rochelle, who had been a paralegal there for 3 years before she resigned and filed an EEOC complaint that had quietly stalled in bureaucratic process. He read the complaint. He read the firm's response. He read 4 years of civil court records related to Vincent Schaefer. And then he made a call. To a former student he hadn't spoken to in 11 years. A woman named Beatrice Okonkwo, who was now a senior partner at a civil rights practice in Cleveland. "Professor Pemberton," she said when she heard his voice. "I need your help," he said. "But more importantly, someone else does." The lawsuit was Beatrice's idea. Camille hadn't known anything about it until Beatrice called her directly. The case was built around a pattern, not a single incident. Rochelle's EEOC complaint. 3 other former employees with similar accounts. Documented communications from firm leadership that ranged from dismissive to openly hostile. Camille's experience was one thread in a fabric that had been woven for years. Langford and Associates hired 4 attorneys to defend the case. Vincent Schaefer appeared on the local Columbus Business News in a 15-minute segment about the lawsuit, where he described it as a politically motivated attack on a successful law firm by opportunistic plaintiffs' counsel. He spoke with tremendous confidence. He had no idea what was coming. The morning of the initial hearing, Vincent Schaefer arrived at the courthouse with his legal team and a consultant from a public relations firm. He wore a charcoal suit and a tie the color of old money, and he walked through the courthouse lobby like a man walking through a room that had been arranged for his arrival. He noticed the old man in the gray work shirt sitting in the gallery. He did not think about him again. The hearing was procedural: motions, evidentiary questions, scheduling. Beatrice was meticulous and unhurried. Vincent's lead counsel, a man named Preston Haas, was efficient and dismissive in the practiced way of attorneys who have won many cases and have begun to confuse frequency with certainty. Then the judge, the Honorable Roberta Kwan, asked a clarifying question about the equal protection doctrine as it applied to hostile work environment claims under a recent Sixth Circuit ruling. It was a technical question, a real one, the kind that had a specific answer. Preston Haas began to respond. He cited the wrong case. Not badly wrong, just wrong enough that anyone who knew the doctrine well would catch it. Beatrice caught it. She said nothing. She wrote one word on her legal pad and slid it across the table to her co-counsel. From the gallery, Aldous Pemberton watched the exchange. He had been watching courts like this for 40 years. He understood every word being said. He understood the small mistake Preston Haas had just made, and what it signaled about the depth of his preparation. He understood the way Judge Kwan's expression had shifted, barely, just a small tightening around the eyes, when the wrong citation came out. He also understood something else. He understood what he was going to have to do before this case was over. He had hoped it wouldn't come to that. He had hoped Beatrice's preparation and Camille's testimony and the documented pattern of conduct would be sufficient on their own. But watching Preston Haas recover from the citation error with smooth, expensive confidence, watching the way Vincent Schaefer leaned back in his chair without concern, Aldous understood that confident men who are accustomed to winning have a particular blindness. They cannot conceive of the thing they have not seen coming. They cannot defend against it. And they had not seen Aldous Pemberton coming. The deposition was scheduled for a Thursday in February, in a conference room at Beatrice's Cleveland office. Aldous asked to be present as a consultant to the legal team, which was his right. He arrived in his gray work shirt. He carried the canvas bag. He sat in the corner chair with a yellow legal pad and a pen, and he did not introduce himself to anyone on the opposing side. Preston Haas glanced at him once and looked away. The deposition was of a former Langford associate named Gregory Tanaka, who had left the firm in 2021 and was willing to testify about the culture he'd witnessed. Preston Haas's strategy was methodical: undermine Gregory's credibility, reframe every incident as a misunderstanding, and make the jury, if it ever got that far, feel that what looked like discrimination was really just the natural pressure of a competitive workplace. He was good at it. He had done it many times. For 40 minutes he worked through Gregory's account with precise, patient erosion. He was not cruel. He was worse than cruel. He was reasonable sounding. He made the incidents seem small. He made Gregory seem not dishonest, but perhaps oversensitive. Perhaps too quick to perceive hostility where none was intended. Gregory's testimony was weakening, not because he was lying, he wasn't. Because the language of the law could do that to the truth if the person wielding it was skilled enough. In the corner, Aldous stopped writing on his legal pad. He set down his pen. He looked at Beatrice. She gave the smallest nod. He spoke, quietly, with the unhurried precision of a man who had lectured on this material for 18 years. "Counsel," he said, "you're applying the Farragher-Ellerth defense to a case where the employer's own documentation establishes they had actual notice of the conduct. The defense doesn't attach under those facts. You know that." The room went still. Preston Haas turned toward the corner chair for the first time since he'd dismissed it 20 minutes ago. He stared at the man in the gray shirt. The name patch above the pocket read Aldous. "Excuse me," Preston said slowly. "Who are you exactly?" "A consultant," Beatrice said. "What kind of consultant?" Aldous picked his pen back up. "The kind who's read every Sixth Circuit opinion on hostile work environment claims issued in the past 12 years, including the one your partner cited incorrectly in front of Judge Kwan on Monday." He looked up from his legal pad. "The Vance decision doesn't support the proposition he was making. I believe you knew that when he said it and chose not to correct him." The silence that followed lasted approximately 4 seconds. It felt much longer. Preston Haas straightened his pen on the table in front of him. He did not respond immediately. "When you have been practicing law for 20 years and an old man in a janitor's shirt just disassembled your legal strategy in 2 sentences with complete accuracy, there is a moment, a specific, unavoidable moment, where your certainty has to recalibrate." Preston Haas was experiencing that moment. "Beatrice," he said quietly, "who is this man?" Beatrice opened a folder. She slid a single page across the table. Preston Haas picked it up. It was a curriculum vitae, 18 years at Case Western Reserve School of Law, 2 Sixth Circuit arguments, 4 published books, the most recent titled Equal Protection in the Modern Workplace, Doctrine, Pattern, and Proof, a bar card current in good standing, and at the top, in plain 12-point font, Aldous Pemberton, J.D. Ph.D. Preston Haas read it. He set it down. He looked across the table at the janitor. He said nothing for a long time. The deposition ended early. Preston Haas requested a recess. He took it. What happened in the hallway between Preston Haas and his team was not witnessed by anyone on Beatrice's side. But when they returned, something had shifted in the body language of every attorney at that table. Not defeat. Something earlier than defeat. The recognition, specific and cold, that the math had changed. Because Aldous Pemberton was not just a consultant who had read the relevant case law. He was a man who had written the textbook chapter that several of those cases were cited in. He had taught the doctrine to a generation of Ohio attorneys. He had argued variations of this precise legal theory before the same appeals court that would hear this case if it escalated. And he had the patience of a man who had sat with grief and come out the other side, which meant he was the most unhurried person in any room he entered. The settlement conference was scheduled 6 weeks after the deposition. Vincent Schaefer did not attend. He sent Preston Haas and a junior associate in his place. That was the first signal. The second signal was the number that Preston Haas's associate slid across the table at the opening of the conference. It was not an insulting number. It was not an offer designed to be refused. It was a number that said, "We have looked at what we are facing, and we have decided that the cost of proceeding exceeds the cost of resolution." Beatrice looked at the number. She looked at Camille. She looked at Aldous in the corner chair. Aldous was writing on his legal pad. She leaned over to Camille and said quietly, "Your call." Camille Pemberton was 22 years old. She had watched her grandfather drive 40 miles to bring her pie and never say a word about the man who had humiliated her in front of 4 colleagues. She had watched him sit in the corner of a deposition room in a gray work shirt and dismantle a legal strategy with the precision of someone who had spent a lifetime building the tools to do exactly that. She had watched him do it without grandstanding, without anger, without anything that looked like revenge. She thought about the others. Rochelle, who had filed the EEOC complaint that stalled. The former associate who had left without telling anyone why. The paralegal who had simply stopped applying for legal jobs and was now working in insurance. She thought about what settling meant to them. She thought about what not settling meant to her. She looked at Beatrice. She said, "I want a public admission of discriminatory workplace conduct. In writing. Filed with the court. Not sealed." The room went quiet. Preston Haas's associate made a note. It took 11 more days of negotiation. Vincent Schaefer appeared in person for exactly one of those days. He sat across the table from Beatrice and looked at Camille, and then, for the first time, looked at the old man in the gray shirt, who had been present at every session, writing on his legal pad, saying almost nothing and changing everything. He said, "Are you her grandfather?" Aldous looked up from the legal pad. "I am." Vincent looked at him for a long moment. You could see something moving across his face, not remorse, exactly. Something more like the slow rearrangement of a man who has discovered that the territory he thought he understood has borders he never measured. "What do you do?" Vincent said. "Currently?" Aldous said. "I mop floors." The settlement was finalized on a Tuesday in April. A signed admission of discriminatory conduct, filed publicly with the court, a financial award to Camille and the 4 other plaintiffs, a mandated third-party audit of Langford and Associates' hiring, promotion, and workplace conduct policies over the following 3 years, with results to be reported to the Ohio Civil Rights Commission. Vincent Schaefer resigned from the firm 2 weeks later. He cited personal reasons. The morning the settlement was announced, Camille called her grandfather. He was at the hospital, 40 minutes into his shift. He had mopped 2 floors and was working on a third. He answered on the second ring. "It went through," Camille said. "I know," he said. Beatrice texted, "Grandpa. Did you know it was going to work? When you first called Beatrice. Did you know?" He thought about that. He thought about the deposition room, and the quiet before he spoke, and the weight of all those years. The lecture halls, the appeals arguments, the textbook chapters, the night shifts at the warehouse, the hospital corridors, Agnes's face in the last years, and Camille's voice going flat on the phone at midnight, telling him about a man who had looked at her and decided she didn't belong. "I knew what I had," he said. "I wasn't sure if it would be enough." "It was enough," she said. "You were enough," he said. The rest was just the law. She didn't say anything for a moment. Then, "Are you at work?" "Third floor's not going to mop itself, Grandpa." "Camille, I love you. I love you too," he said. "I'll bring pie on Saturday. Your mother still can't have all of it." He hung up. He went back to work. In the weeks after the settlement, the story moved the way these stories move. Local news first, then the regional affiliates, then a legal blog that had 400,000 readers, and a headline that the rest of the internet couldn't resist. "Janitor walks into deposition." Turns out he wrote the textbook. The photograph that ran with it was not staged. It was taken by a Columbus Dispatch photographer outside the courthouse on settlement day. It showed Aldous Pemberton in his gray work shirt, standing on the courthouse steps with Camille beside him, both of them squinting into the afternoon sun. He looked like what he was, a 71-year-old man in a worn work shirt, who had somewhere important to be. He looked like nobody. That was the photograph that went everywhere. The comments, hundreds of thousands of them, said things like, "This man walked in as a janitor and left as a legend," and "the most expensive assumption Vincent Schaefer ever made," and "I'm not crying, you're crying," in a deposition conference room, and one that got shared more than any of the others, posted by a woman from Cincinnati who had worked in corporate law for 15 years. This is what happens when brilliance is forced to live quietly for long enough. Eventually, the room gets too small to hold it. The Ohio State Bar Association invited Aldous to speak at their annual symposium in September. He accepted. Case Western Reserve contacted him about a named endowed lecture in his honor. He said he'd think about it. What he actually did, on the Saturday 3 weeks after the settlement, was drive to Columbus and sit at Camille's kitchen table with a sweet potato pie, and let her talk for 2 hours about her plans. Law school applications, which firms she was interested in, what kind of law she thought she might practice. He asked questions. He listened. He refilled both their mugs twice without being asked. When she ran out of steam, she looked at him across the table and said, "When did you know about the law, that it was what you were supposed to do?" He looked at his coffee. He thought about his own professor, 50 years ago, a woman named Dr. Estelle Rowe, who had handed back his first paper with 2 words written in red at the top. "You see it." He had never forgotten that. He had spent 18 years trying to make sure the students who sat in his classroom knew that someone saw it in them, too. I knew when I understood that the law isn't just rules, he said. Rules can be bent by whoever holds them. The law, at its best, is a structure that protects people who have no other protection. When I understood that, I understood why it mattered. Not as a career, as a reason. Camille looked at him for a long moment. I want to do what you did, she said. The teaching part. Eventually, you'd be good at it, he said. How do you know? Because, he said, you already understand that the work is for the people, not the work. That September, Aldous Pemberton stood at the podium of the Ohio State Bar Association Symposium in front of 600 attorneys. He wore a dark blue suit that had been tailored for him in 1999 and still fit. His notes were on a yellow legal pad. His reading glasses, the same ones he wore on the hospital's third floor, sat on his nose. He didn't open with a case citation. He opened with a story about a woman named Rochelle who had filed an EEOC complaint that sat in a file for 2 years while the system moved slowly. And the people it was supposed to protect kept getting quietly pushed out of rooms where they deserved to be. He told it simply. He didn't editorialize. He let the facts carry the weight, the way he'd always believed good legal argument did. By the third minute, you could have heard a pen drop in that room. At the back of the auditorium, in the last row, sat Camille Pemberton. She was not taking notes. She was just watching her grandfather, who had spent 20 years being unseen and quiet, and fully completely himself the entire time, stand at a podium and remind 600 attorneys why they had chosen this profession. She didn't take a single note. She didn't need to. She had already memorized the most important part. Not the doctrine, not the citations, not the Sixth Circuit's evolving interpretation of Harwick's discrimination standards. She had memorized the way he stood, feet steady, shoulders level, hands loose on the lectern, the posture of a man with nothing to prove and every reason to speak clearly. There's something I keep coming back to, thinking about Aldous Pemberton standing in that deposition room in his gray work shirt, while a man in a $2,000 suit looked at him and saw nothing. The assumption of smallness is always the mistake. Not sometimes. Always. Because the people this world passes over, the ones moving quietly through other people's important days, mopping the floors, filling the coffee, stepping aside in hallways, those people are not empty. They are not waiting to become something. They already are something. They have always been something. The world's failure to notice is the world's failure, not theirs. Aldous didn't walk into that deposition room to prove a point. He walked in for Camille, for Rochelle, for every person who had been told, in words or in silence, that they didn't belong in a room that was built on principles that said otherwise. He walked in because he had spent 18 years teaching that the law, at its best, protects the people with no other protection, and when the moment came, his body already knew what to do. So I want to ask you something. Drop it in the comments right now. Have you ever underestimated someone and been wrong? Or been the one who was underestimated, written off, passed over, looked through, and found out later that you had exactly what the moment needed? Because I read every comment. Everyone. And next week I'm bringing you a story about a woman who was dismissed from a boardroom for the last time. What she did next didn't just change her life. It changed the building. Don't miss it.